Good evening to the students of the SLW670, that is the Advanced Intellectual Property Law, and hence I told you that I will continue till the last but one examination regarding the IRAC and PFIRAC model, and with that view I would like to keep my promise whether anyone be present or not. And this is the case law which is unreported in the High Court of Tanzania Commercial Court Division at the Dar es Salaam Civil Case number 6 of the 1999 Kibo Match Group Limited. There is the applicant plaintiff versus Mohammed Enterprises Tanzania Limited, respondent and defendant. Perhaps most of the people know the Mohammed Enterprises T Limited. That is nothing but one of the sister concern of the R component of the Azam company. That is the proprietor Janab Bakhresa, if I not be mistaken, subject to the correction. So the ruling is given in this case law by Kalageya J, and who gave the ruling. And this is about the intellectual property right, especially for the trademarks are concerned. So what it is said here in this ruling, matters to be decided are two. What are they? These two are nothing but the question of law. In one sense, in another sense, it is the issues. The defendant's preliminary objections and plaintiff application for the temporary injunction. The first preliminary objection is that whether this court is having, means commercial division is having the jurisdiction to entertain the trademarks or counterfeit trademarks cases or not. Perhaps that is the first preliminary objection. And the next is the plaintiff application for the temporary injunction. And he wanted that the plaintiff a temporary injunction should be given so that he could save his reputation and money incurring the loss also. So each party wears the trapping of the both an applicant and respondent. They try to trap each other depending upon the matter being discussed for avoidance of the confusion in this ruling. And he will not use this title as is usually the case, and instead I will maintain the main title of plaintiff and defendant. So here the plaintiff is Kiboko Match Group Limited and the defendant is Mohammed Enterprises Tanzania Limited. So the above tussle, the question of law emanates from the plaintiff action against the defendant, by which he seeks, among others, a permanent injunction against the said defendant, restraining the latter from the infringing its registered trademark. So what is that? The plaintiff contended that it is the registered trademark by name of Kangaroo as far back as 10th October 1989. The trademark of the Kangaroo, it is as back of 10th October 1989, and it has since then been exclusively manufacturing and selling both the internally and abroad the matchboxes bearing the said trademark that, however, in the violation of that exclusive rights of the defendant, have been importing and selling the matchbox with identical trademark. Who is selling the identical trademark? The second defendant. Who is the second? Not the defendant. Who is the defendant here? Mohammed Enterprise Tanzania Limited. He is importing the same type of the matchbox and selling in Tanzania. But the trademark which is held by the Kangaroo company, the Kiboko matchbox, the trademarks. So the trademark, an estimate loss as a result of this infringement to have struck at least here they say 1, 10, 100,000, 10,000 lakh. So 1,544, 498, 687. Now you can make it out. It is the 1 million and 154,498 or something like that, or more than that. So mark as the 10th September 1999. So how much they incurred the loss is 1,544,498,687. That much Tanzanian shillings was there. Pending a final determination of the controversy, the plaintiff applies for the issuance of the temporary injunction to restrain the defendant. The defendant should not supposed to import such a matchbox and sell in the Tanzania, because there is a infringement of the trademark, there is infringement of the Kiboko trading company which is registered there in Tanzania under the Companies Act, including the other trade, whatever the trade marks act are there, if it is so. So whether by its officers, servants, agents or any other of them, otherwise from the infringing the or passing of the applicant's trademark by the way of in importation and distribution and sale, either you can import it, distribute it, sell it, advertise it, or otherwise safety matches under the names of the device kangaroo. You are not supposed to do so because already trademark kangaroo is there and which is manufacturing the matchboxes. In response thereto, the defendant came up with the preliminary objection. What the defendant did say? The Mohammed Enterprise Tanzania Limited, they say that, number one, the alleged trademark infringement is not a commercial case as defined in the Rule 2 of the High Court Registries Amendment Rules 1999 and read together with the High Court Registry Rule 1984. That is a preliminary objection raised by the defendant. It doesn't come under the commercial jurisdiction because he stated the rules also. And number two, the affidavit of one Deodatus Lucas Ubena Kinaviro is hereby evidence and not competent to support a chamber summons. And again he says the chamber summons are not supported to use, not competent to use such a summons according to the affidavit given by the Deodatus Lucas Ubena Kinviro. The third one is the affidavit is otherwise defective in law. The affidavit which is filed by the plaintiff is defective in law. These are the three preliminary objections made by the Mohammed Enterprise Tanzania Limited. And the Captain Kameja of Bajar, Ravechangura, and Kameja and Nugulma advocates. These are the advocates representing the plaintiff. Plaintiff, who is the plaintiff? Kiboko. The Kiboko man. The Kiboko Match Group Limited, the kangaroo which is having the trademark, and they represented by the Captain Kameja of Majar and Ravechangura and Kameja and Nugulma advocates for the represent the plaintiff, while Chandu represented the defendant. Mr. Chandu is there, and who represented the defendant, that is the Mohammed Enterprise Limited. With the leave of the court, the counsel argued both the preliminary objections and the application of the temporary injunction together by the way of written submission. So they challenged the issue of the preliminary objection as well as the plaintiff contention to issue the injunction not to proceed further. So in support of the preliminary objections, Mr. Chandu argued that trademark infringement cases are not commercial cases as defined under the Rule 2 of the High Court Registries Amendment Rule 1999 and read together with the High Court Registry Rule 1984. That is his contention. Chandu contention is it does not come under the jurisdiction of the commercial courts. And of course he has given the reason for that also in the explanation over here. And Mr. Chandu also had a quarrel with the affidavit, and he said he doesn't agree with the affidavit which is filed. He argued that the Deodatus Lucas Ubena Kinevario affidavit simply refers to the private investigation report, which is not signed, and therefore it falls when the verification clause within the states. So it is not a proper authority to do such an affidavit, and is not properly signed over there also. And he stated in that clearly he made the charge. What is stated above is true to the best of my knowledge. Now that is not the knowledge of the deponent. The affidavit out have disclosed the basis of his information he charged. He made the disagreement of the affidavit also. And in response to the plaintiff counsel argued strongly that the plaintiff's counsel, who are the three members The advocates just now I read it, but only one advocate, Chandu, is from the defendant side and strongly defended the defendant's importation, distribution, and selling of the matchboxes are commercial activities that has these infringes the plaintiff's trademark. The resultant is the commercial dispute falling under the definition of the commercial cases as provided in the Rule 2, Class A and Subclass 4. Because selling, distributing, and importing, these are nothing but commercial activities. Alternatively, he argued that the definition of the commercial case is very widely couched under the Rule 2, small a, so as to encompass the matter of the commercial significance. It is having a broad outlook, a broad area, which phrases covers the general ambit of the use of the trade or serviceman's and on goods in commercial transaction, and the alleged defective affidavit is stated. Of course, he has made his own argument. The Kinario affidavit is concerned. The applicant was well aware of the infringement before the commissioning the investigators. They will call in the confirm by way of the through the investigation that the applicant already knew. That is the infringement of its trademark by the respondent. It is already knew that it is the infringement of the trademark of the affidavit by the respondent. I should outrightly state that the preliminary objection has no base on which to stand. Of course, the contention is made by the parties' counsel, who are the plaintiff counsel, starting with the argument that the disposed invoking the trademark are not covered under the definition of the term commercial case. They said, starting, yes, the commercial activities, what did they say? It will not come under the definition of the commercial cases, but they made a proof that definitely it will come under the commercial trade because it is nothing but the trade and the trade and the commerce are concerned, which is the business purpose for getting the profit, hence it is a commercial case. So, under the amendment rules of 1999, he has given the own statement. Commercial case means a civil case involving a matter considered to be of the commercial significance, including but not limited to. Of course, he has given many points. What are the included over there? 1, 2, they have made 12 points totally. And here and there I will make it out because it is already seen on the screen. The formation of the business of the commercial organization, the governance of the business and the commercial organization. Third, the contractual relation of the business and the commercial organization with other bodies or the person outside it. The fourth, the liability of the commercial business and organization or its official arranging of its commercial or the business activities. And fifth, sixth, seventh, eighth, you could see on the screen, which is clearly given, and it is all in there in the website also, and you can easily download it and make it out. Just you type in the Google search in the name of the case law. Is enough. The enforcement of the commercial arbitration and so on forth. The last but one is nothing but the 11th, admiralty proceedings, and the 12th one is arbitration proceedings also come under the definition of the commercial cases. So it however be noted that the item should be 11 and 12 item X is inadvertently indicated. It is not an independent item but falls under the. Of course, there is some other point they argued over there. But what is provided above, it would amount to the absurdity to entertain the argument of the dispute in which the business frontness action against the other complaining the party and has infringed his trade. So overall what they want to say is that importing, selling, advertising, making the profit is nothing but a commercial function. Hence, the commercial code is having the jurisdiction to entertain such a case. So that is the outcome which is given over here. So the identical marks, hence capturing the otherwise potential customer through the deception. Significance of the dispute over the production and the distribution of the articles of common or public today. Utility like the matchboxes need no emphasis. There is no such a thing because it is a consumable item. With the above picture suffice to state that the dispute at squarely falls under the definition of the commercial case. It is squarely false without any doubt at all as provided in the item 4 of the Rule 2 above quoted. The same fate befalls the rest of the objection, which is the substance are there, And the other thing also, the affidavit also is countered, and they also maintained that yes, permanent injunction should also be given because there is irreparable loss happened to the plaintiff. Where people are purchasing the imported goods, feeling that it is the kangaroo match boxes. So they have given the para 6 and 7 allege that the imported match boxes are of the poor quality. The defendant has profited through his deal, that the plaintiff has suffered a loss of 1,544,498,687 on the date of the 30th 9 1999. In para 8, deponent states that if the injunction is not granted, the loss will be closer and the damage suffered will be an unquantifiable degree and irreparable loss will be there. Hence, his contention was that it should be, a grant should be given in temporary as a ruling. Later on, the case will be continued based on the arguments are concerned and the proofs and evidences are given over there. So with respect to Mr. Chandu, and who is arguing on behalf of the Mohammed Enterprise Tanzania Limited, have not come across any paragraph which specifically offends him. As I have summarized above, all matters are stated by him, that is Kinvairo, to be in his personal audit. As rightly argued by the plaintiff, it is categorically stated that the plaintiff sought the assistance of the private investigation just for the details of the confirmation. The scrutiny might be done by any other person, but the reality is that yes, irreparable loss happened because similar type of the things which is imported and selling the market, and the people are thinking that the tobacco industry is preparing such a boxes and they are purchasing it. Actually, it is a dupe under the infringement of the trade name. It was sold by the Mohammed Enterprises. The plaintiff had already noted that the infringement before the putting the investigation into the field. Before the investigation, he also made it over there. A report will be made it over by any other private body, and he made it very much clear that there is an infringement of the trademark is there to the defendant. As a principal officer of the plaintiff company, he stated that he was aware of the before the private investigation was conducted, where an element of the alleged hearsay in this. The report may not be signed, but as this preliminary stage, this is quite irrelevant. But the affidavit are more, especially the verification clause is legally perfect. The other part of the preliminary objection also crumbles the seal of the fate of the preliminary objection. So we now turn the application of the temporary injunction. Yes, it should be given. Otherwise, there would be irreparable loss, and the loss could not be imagined by the persons, those who suffered it, and here the plaintiff. So in support of the application of the plaintiff counsel vigorously argued that on the set of the fact, 3 conditions for the issuance of the temporary injunction have satisfactorily been established. What are the 3 grounds where the 3 or 4 advocates who are arguing on behalf of the plaintiff? In support thereof, cited, that is a case law with Attilio versus Mbove, that is the 1969 High Court Digest 284, and the Gila versus Casman Brown and Company Limited 1973, the East Africana 358 page, and the CPC, where the CPC International versus Zainab Grain Millers Limited, that is the CAT Commercial Division is also, and a civil cat, that is civil appeal of the 49 of the 1985, and there also the Court of Appeal at the Tanzania. And he argued that by providing that it is a registered proprietor of the trademark kangaroo since 10th October 1989. And you know that what is kangaroo? It is a very, very famously be seen and known in the kangaroo land, that is Australia. Yes, 10th October 1989, which marked the depicts the picture of the 3 kangaroos and the word kangaroo printed therein, prominent yellow bold capital letters, and also having the proof that the defendant imports, distributes, and sells goods with a similar mark, the plaintiff have established a prima facie case. So there are 3 kangaroos are there, the word of the kangaroo printed therein with the prominent yellow bold capital letters on the match boxes. Yes, the plaintiff has established the prima facie case on this. He refers the Colgate Palmolive Company. This is another case law versus Zakaria Provisions and Stores and the others. There is the High Court decision civil case number is supported, and Tanzania Breweries Limited versus Kibo Breweries and Kenya Breweries Limited. This is also case law where the similarity would be there in the trade. Marks are concerned, logos are concerned, and and the irreparability of the injury, he insisted that if by the 3999 there it is clearly mentioned how much it is there. It is nearly 1.5 billion marks. Continuing the breach will escalate the amount involved to an unaffordable sum of the terms of the payment if that injunction is not granted, thus ending up with the just decree of the permanent injunction in case the matter is decided in their favor. Okay, either this favor or any favor, but importing and selling such a similarity of the kangaroo marks, matchsticks imported by the Mohammedan, that is Mohammed Enterprise Tanzania Limited, Mohammed Enterprises Tanzania Limited, and whose property is Bakhresa or Azam Company. This is just a degree of the permanent injunction in a case that the matter is decided in their favor, and even in terms of the balance of the conveniences. The defendant has a very little to suffer if temporary injunction is granted as compared to the plaintiff, because the farmer, which is neither a registered owner even a license of the trademark, will just have the temporary cessation of the business, while the later affected the circle include the loss of revenue and the loss of goodwill due to the deception and confusion relating to the infringement. If merely giving the temporary injunction against selling and importing and distributing such a similar type of the goods, though not a loss to the Mohammedan Enterprise Tanzania Limited, but definitely it will be lost to the Kiboko industry, because that industry is a small scale industry and producing these kangaroo matchsticks, and they are the small units where you compare with the Mohammedan Enterprises. They do the group of the companies would be there, and hence in front of them they cannot stand, and hence they will ask them to issue the preliminary, that is the temporary injunction at the time being, and the objection of the preliminary objection of the made by the Chandu, and who argued on behalf of the Mohammedan Enterprise Tanzania Limited, and he is having not that much a proof to give it in detail, when a natural justice would be there, a small man and who is doing such a business and he incurred such a loss would be there, and his company will become on the roads if temporary injunction is not given. Hence, the court is thinking, yes, temporary injunction should be given. And in addition to that, what is the preliminary objection which is made over there? The business which they are doing does not come under the commercial definition. Yes, the objection is overruled and stay. The transaction definitely will come under the commercial cases would be there, even though the plaintiff did not register itself in a particular company, but he is registered in the Companies Act is concerned. If any necessary things are there to register it, later he can comply it, but in the beginning that he is incurred a loss, and that is an irreparable loss that he find it hence, and he argued and he made to satisfy the judge also to issue the temporary injunction by the four who are argued on behalf of the plaintiff. So in response, the defendant counsel argued the plaintiff trademark is no longer valid as it expired 7 years after the registration in terms of the Section 23 of the Trade and Service Marks Act of 1286, because the time period is over if it is so, but it can be renewed also. Secondly, the defendant agreed that the Section 33 of the said Act specifically preserved the anterior right of the person to continue to use the said mark. In other words, it is preserved the right of the another person to continue to use the similar or identical trademark if he had used the said mark prior to its registration. Prior to the registration, if any person has used such a trademark, yes, he can do so. But The registration is made by the first defendant is earlier, and the second defendant is made such a business that the import a later part, and hence there is a clear provision would be there. It is he infringed the right of the first plaintiff, and who has hold such a logo or such a trademark and such a figure of the three kangaroos, and kangaroos written in the yellow color bold and on the matchsticks cover, that is sold in the matchstick having such a cover over it. So what that want to say is that and that on facts of the matter of the defendant stated importing the identical goods, because when you look at it, it is identical, even though a letter, a small letter would be there, maybe there, may not be there, like we discussed in the case law, J.C. DeCox versus J.P. DeCox case law that we discussed. Only J.C. and J.P. is only there. Instead of C, it is the P is written. But J.C. company is having 134 countries registration would be there, and it is having a branch. Of course, South Africa has purchased the license, but actually the family name of the French people, which is having dominating in the 134 countries, they do have the such a registration. And this JP company, which is made it earlier, which looks like alike, even though it is registered over there, but the people will be confused, and it is also proved in the court of law that yes, the infringement would be there. At the international level also they made it, or online, in an online place also they made it, and they also proved it in the court of commercial court division in Tanzania. So there is a confusion is there, hence there is a trademark violation is there, a counter with the trademark, and the registered import duty entry document which is an annexure to the written statement of the defense, and which shown in the importation of the cartons of the match boxes having the similar type of the kangaroo photos, and in the bold letters it is written in the yellow also. So thirdly, the seemingly intended to be in the alternate, Mr. Chandu, he is arguing on behalf of the Mohammedan Enterprises Tanzania Limited. The plaintiff, they said, has failed to produce a single document emanating from the respondent to show that the respondent has imported the sold safety matches bearing the trademark of the appellant. See, the point is when the imported itself is enough. If it is there, of course, when he said a temporary that he incurred so much loss, in generally, yes, it will be sold in the market. And the people, they found it. They thinking that it is manufactured by the Kiboko industry only. So in reply there to the plaintiff counsel called upon the court to disregard the defendant's invitation to deal with the issues travel in the main suit, the points as such issue to include the whether the plaintiff trademark is still valid, whether it confers the exclusive right. In the beginning, if he made it, even though he did not continue it, but still it can be said that it is a violation of the trademarks. Because honestly believe that one should not do. Yes, if they want to import any matchsticks, let them have any other mark, not necessarily this mark. For India, you say the matches, 3 mangoes matches are there. 3 mangoes. That is very much famous in India once upon a time. Let them import it and sell the match. Even instead of 3 kangaroos, 3 mangoes matchsticks, which will be sold in Tanzania, imported from India at the cheaper level, cheaper price. So here they say the plaintiff trademark is still valid whether it is confers exclusive right or not, because they maintained from the beginning in the beginning, yes, before the Mohammedan Enterprises started importing such a matchstick from the other countries to the Tanzania. So I will start by stating that the principle of governing the institutions of the order of the temporary injunction are generally captured on the 2 main premises: how and when the temporary injunction will be given. So the application, yes, and the order of the temporary injunction are generally captured on the 2 main premises. Yes, Karibu Sana. 2 main premises. The applicant should show a prima facie case with the probability of success against the defendant, number 1, and also should prove that if the injunction is not granted, the injury that would be suffered would be irreparable irreparable loss by way of the damages to the plaintiff. So, embraced under the law's premise is the principle of the balance of the convenience is concerned, that the applicant would stand to suffer greater hardship if the order is refused than the respondent would suffer it if granted an antilio, the case law, the GILA case law, CPC case law, international case law cited above by the plaintiff are very clear on these principles. If the injunctions are not granted, then the plaintiff will suffer a irreparable loss and his loss will be escalated in a geometrical progression, and where he should have to close the industry and his assets will be on the roads because of the finance that he could not make it out regarding the salaries and the capital is concerned. So on the basis of the pleadings and the parties' argument before me, I have no hesitation to hold that prima facie case has been established by the plaintiff against the defendant. So is the irreparability of the injury is there by to the plaintiff by the act of the Mohammed Enterprises Limited, who is the defendant here. The plaintiff has put before is the following, that Kangaroo is a brand which will manufacture the matchsticks in Tanzania, the trademark, and was registered in the 1989, and that armed with this has manufactured the sold matchboxes bearing the said mark, that the defendant then imported and sold matchboxes from India bearing the identical trademark as that of the Kangaroo, that is 3999, loss of revenue due to the defendant's infringement reached over to nearly 1.5 billions because of the act of the Mohammed Enterprises of the counterfeiting trademarks business if he undertaken in the Tanzania, importing the matchstick from India. On the other hand, the defendant did not bother to challenge any of the above and instead engaged in a technical front, impliedly admitting what the plaintiff was contended. Of course, the most of the contention of the plaintiff that the defendant admitted, because it is the reality and the true also. The defendant does not challenge that the trademarks on the plaintiff matchboxes and that one that imported matchboxes are identical. This is nakedly true. So, notwithstanding the defendant seemingly vacillations to one point at one stage of disputing another having imported the offending goods and yet other admitting the same, but one gather from all the round arguments fronted is that they admit importation. So many of the contentions raised by the plaintiff, they accepted. Chandu has accepted. Even the defendant has accepted. And here and there they contravented it, but they say what they imported is not identical to it. But it is proved that what they imported is very identical to the marks which are registered by the first company, that is the Kiboko Manufacturing Company, and which has incurred the loss nearly 1.5 billions because of the importation of the matchstick of the similar nature, the Kangaroo, three Kangaroos nature, having the bold letters on it in the yellow color. So with respect to the Chandu, who is arguing on behalf of the Mohammedan Enterprises, the technical argument presented that the trade mark is no longer valid and the plaintiff have no exclusive right over its use, as rightly contended by the plaintiff, are the issues which cannot be argued at this stage. Now, whether he is having that right or not, but once it is registered over there, there is a different issue. Whether the registration is valid or it should be renewed. The registration for getting the further extension of the trademarks are concerned. So these will be argued in the main hearing by the production of the relevant evidences later on. But the ruling was given in the first that the injunction should be given against the Mohammedan Enterprises not to import or sell such a matchsticks which are similar in nature to the plaintiff Kangaroo matchsticks. So that is the premise. Yes, Kabirisan Bibilian Kilio. On the facts of this case law, therefore, there is no need of discussing the authorities that rely upon the plaintiff. There is no, because the defendant has not put up any challenge. The existence of the trademark has been established under the section 50 of the Trade and Service Marks. In any legal proceeding, registration of the trademark is the prima facie evidence of the validity of its original registration. whenever a trademark would be there, generally either it will be registered in the Companies Act or the latest act of the Trademarks Act is there. Yes, they have to register it so that nobody could make such a thing. And if anybody makes such a thing would be there, yes, he will be challenging the court that he made the counterfeit trademarks, which are having the similarity nature with the other company. So under section 50 of the Trademarks and Service Marks, Trade and Service Marks in any legal proceedings, registration of the trademark is the prima facie evidence of the validity of its original registration. So under the section 50, registration is must. So the registration in the plaintiff name, the defendant imports goods bearing the identical trademark. The defendant has not claimed any joint proprietorship, nor is being licensed or related. Suppose if he has taken the license from the first company, then he can do so. The defendant has not claimed any joint proprietorship, nor is being licensed or related, and whatever the consciousness would be there, the plaintiff stands to suffer irreparable loss, and the defendant, if injunction is refused. If the injunction is refused by the competent court, at that instant, definitely the plaintiff will suffer irreparable loss, and the loss will be escalated also. It is no wonder that the later had the guts and one point of the disclaiming being an improper of the offending goods. Yes, even offending goods are there. If a defendant knows that he is importing the offending goods, which is having the similar nature of the plaintiff goods, at that instance, the act is done intentionally. So from the totality of the above, I am satisfied that, because who satisfied? Kalagaya, he is a judge, honorable judge, satisfied that the plaintiff has approved its application of the temporary injunction, and the same is accordingly granted. So that is given by the judge, L.B. Kalagaya. Yes, Devota is waiting. Okay, I allowed her to enter into the main lobby. So this case law I have read, given the total judgment of this case law. It is decided by the Commercial Court Division at the Dar es Salaam, civil case number 6 of the 1999, and the parties are Kibo Match Group Limited, applicant and the plaintiff versus Mohammedan Enterprises Tanzania Limited. He is the respondent and defendant. Because when you read the entire case law, you can easily understand. When you are writing either the case briefing, that is the pre-FIRAC model, or writing the problem solving. In the problem solving, that the examiner will give the facts, the problem, and there you have to write in the IRAC method. So facts are already given over there, then you need not worry about it. But only what are the issues are there, that is more important. But here there are 3 preliminary issues are there, and another ground is, the first ground is 3 preliminary issues, the second ground is injunction, granting the injunction. Only the 2 issues are here. And the first primary injunction, that this case will not come under the commercial division, according to the rules they have framed it by the Chandu. And the affidavit filed by a private party is not a proper manner. The third is, they said there would not be any violation of the trademark would be there, or irreparable loss is caused to the plaintiff. That is the third objection. And the preliminary objections are cut. The second ground is that injunction. If the injunction is not given or not granted, because by the time the Mohammedan enterprise imported and sold the goods in the particular time, the incurred loss is 1.5 billions by the
Mungu ibariki Afrika, wabariki viongozi wake, hekima, umoja na amani. Hizi ni ngao zetu Afrika na watu wake. Ibariki Afrika, ibariki Afrika, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Asante sana, sikiliza darasa. Mungu akubariki na kukulinda.